We're all good.
All right, any matters not listed on the agenda? I mean, everybody's had a chance to read the September minutes. Comments or motion?
I as well was not there.
I move to approve. The second, approve last.
Second.
Okay. All right, discussion? All right. So our first proposal to look at is Oak Fields.
Could we, sorry, I didn't catch, there were some abstentions.
These
Two abstentions, everyone else in favor, presumably.
Welcome.
Thank you. Okay. So the first order of business is a donation proposal that the authority saw in its August meeting, but some of you here weren't there for August, so I'll go through it again. We also have the landowner's attorney here with us, Mr. Alves. This is a 87-acre property northwest of Free Union, just off Wesley Chapel Road. An easement on the property would eliminate approximately 15 potential dwellings. The resources on the property include 2 acres of critical slopes, all of which are above the intermittent stream which flows into the South Fork Rivanna Reservoir. Contains 77 acres of important agricultural soils and connects to existing conservation easements, one large block in the north with another protected property in the south. The proposed terms are for no subdivisions, 3 parcels to be treated as one. The landowner was advised that this body, as of previous meeting, encourages owners to combine parcels and chose not to do so. There would be 2 dwellings permitted. There's 1 dwelling currently on the property, and it would permit 6,500 square feet of above ground enclosed living space across the 2 dwellings. The dwellings must be in the building envelopes shown in white. You can see the existing dwelling is here in this building envelope and must be replaced within that same building envelope. The second structure, which does not exist, or the second dwelling, sorry, which does not exist, may be in one of these 3 building envelopes. Once it's placed in any one of the 3 envelopes, it then has to be replaced in the same building envelope. So functionally, the other 2 unused building envelopes then would just go away, wouldn't matter to the easement. The standard terms for accessory structures and farm buildings, except no structures over 500 square feet within the 300-foot setback. And also proposed is a 200-foot riparian buffer in the north, which covers those 2 acres of critical slopes that we showed you on the previous map. So we find that it meets the acceptance criteria and we recommend acceptance. I'll just clarify as well, the comments since the August in the August meeting, the comments were you wanted to see the building envelopes, so they have been provided. You wanted the 300-foot setback, which the landowner agreed to, and you wanted the dwelling to be replaced in the same location, which the landowner has functionally agreed to. It's restricted to that 1 acre building envelope. Happy to take any questions.
What is the, you've got 3 building envelopes. What's the 4th white shaded area to the west?
No, that's a riding.
This
Yes.
this is an outdoor riding.
4.
Middle.
The envelopes pertain only to residential.
Correct.
Dwellings, not ag buildings.
Yes.
Okay. In fact, there's be an ag building right there.
Yes, this structure between the two building envelopes, that's a.
We just
a
seem
barn.
odd not to connect those two envelopes, but you know.
I'm just curious, James, how do you, define the building envelopes? What do you, how are they established where they actually are on the plan?
The landowners send us GPS coordinates, and we mark within the exhibit of the deed, we list the GPS coordinates of the corners.
So you don't do the GPS yourself?
Provided by the landowner.
Yes, that's in this case. In some cases, the landowner will provide us a screenshot of something, and
And then you'll.
I'll try to match up GPS and send it back, and we'll confirm.
Where did the 200-foot riparian buffer come from? Stream?
That was it was 200 feet to include all of the critical slopes. There's a pretty steep bank.
Got it. Fair enough.
Pretty straightforward.
I would that we approve it. It's simple.
Further discussion? All in favor for approval? Aye. Vote. Thank you, James.
Thank you. And thank you, Charlie.
Yeah,
I guess maybe not. Thank you.
Well, I think if I had been here the first time, we could have. Thank you all very much.
Thank you.
Thank you for your patience with your client doing the progress. So, thank you.
Okay. So next we have another donation proposal. This one is owned by Mr. Dick Ergler. It's 28 acres in Whitehall, fronting on Garth Road. And an easement would eliminate approximately 7 dwellings. 7 potential dwellings, I should say.
Yeah, I was just trying to wrap my head around where it was. Is it Garth Road or Whitehall Road at this point?
It is Garth Road, as I understand it.
It becomes Whitehall right in store.
This is the kind of main intersection in the middle of Whitehall with
Yeah, okay.
White's Hall is down here.
Okay.
This used to be an orchard, as I understand it. I'm not sure if it was a public or private orchard, but
Moppins, maybe.
yeah, Scott seemed to know of it as a former orchard.
Pretty good one.
The values include 1,500 feet of intermittent streams in the watershed of South Fork River Reservoir. All of the soils are listed as important for agriculture, and Garth Road is a Virginia byway, which means it has high aesthetic or cultural value. The term sheet lists no subdivisions, 1 dwelling permitted, which currently exists, or its replacement up to 4,500 square feet to be contained within the white building envelope.
So that's this right here.
That's that, yeah.
Okay.
The pink shapes are indicating critical slopes here, but currently per county regulations, buildings aren't allowed on critical slopes, and have also suggested to the landowner to add something into the easement itself to restrict, to not allow buildings to be placed on critical slopes. Just to clarify, just because the critical slope is within the building envelope doesn't mean a dwelling could be placed on it. Standard terms for accessory structures, farm buildings would be limited to 2,500 square feet footprint, except unless if the holder grants permission for a larger building. And again, there's a setback here, a 200-foot setback, where structures over 500 square feet would not be permitted. I've highlighted the footprint limit as well. This is a standard footprint of 1% of the property, but because it's such a small property, that's just over 12,000 square feet for all structures. And the riparian buffers proposed a 35-foot buffer on the western stream, which is not currently forested. There are a few trees right on the bank, but it's not forested, it's in pasture. And 100-foot riparian buffer on the eastern stream, which is currently forested. So again, we find it meets the acceptance criteria and recommends acceptance.
On the dwellings, that is one dwelling in addition to the existing or?
No.
Replacing the existing?
Just one dwelling.
Can I just suggest from your standpoint that you reconfigure your building envelope so that you don't have a critical resource in it? I mean, it's sort of bad form. You know what I mean?
Yes, I saw that. And I admittedly not experienced with building envelopes, so I appreciate
Different
that.
shape, man.
Well, I was wondering, is it better to have the resource in the building envelope and say explicitly this isn't included, or to draw a building envelope that goes, you know, a kind of squiggly building envelope that goes right up to the current dwelling and excludes the critical slopes?
That's what I would.
If the latter is preferred,
Yeah.
then I'll
I mean, I
take
would-
that into account.
Go across to here, move a vertex there, and I would go down to there.
Yeah.
And if they want more ground, come over here.
Mhm. Thank you.
It is nice to have just from a clarity perspective, 4 corners or X
Mhm.
number of
Right.
clear corners.
Oh, but 5 or 6 will do.
Fair. Yeah.
I mean, if 5 or 6 describes the area.
Yeah, I'm not disagreeing. I'm just saying that I think what you were trying for is simplicity, which I think is also a good
Yeah.
thing.
And the problem is to make it 4, you end up having to go through the porch of the house, it looks like. And it'd be just as well not to do that.
You're gonna ask the same question? Does he own the 2 I can't recall. I visited with him a bunch of years ago. The front parcel to the left and then he
Yeah.
has some additional land there,
He owns this parcel on Garth Road.
and he doesn't own the one in the middle, right?
He doesn't own this one. This is where he lives. It's a small 2-acre parcel with 1 dwelling on it. That's where he lives.
And that's right behind the store, sort of.
No, the store's to the left.
Just to the left. You can see the parking lot, the Alliance store right there.
This,
That's.
Oh,
There's a road right in front of it.
So the, this one has a 200-foot setback. The other one was 300. Is there a formula that you use for frontage or?
not a formula, but there are reasons. The other one was 300 feet because in August, you all indicated you didn't want large structures blocking the view of the dwelling. And so 300 feet was up to the dwelling. And in this case, I think 200 feet, 300 feet was getting into the building envelope they asked for.
Right, yeah, so, and it looks like in that shaded area, what's in that little shaded area? Is that roads or?
This shaping, this is the old orchard that's now overgrown.
So all those little white images or,
That's clearing between the orchard trees.
oh, okay.
So aside from that efficiency, we could probably move to approve since it looks okay, but aside from some arts and
can
crafts. on the-
Approve with that being a condition.
Nobody want to make a motion?
So moved.
Second.
Second. Second.
Okay, Mr. Taylor. Further discussion?
Do you ever have concerns from landowners doing partial easements where they're not putting the entirety of their adjacent holding under easement? Have you talked with him about the full Monty?
Yes. And he and his representatives asked us to produce 2 versions of this, one with both parcels and one with just this one parcel. and he decided to go for this version. I think because, if I'm remembering correctly, I think because he has two daughters and wanted to be able to kind of give each of them a part of it. I'm not certain on that, but I think that it was estate planning purposes.
Presumably they're.
Potential.
They're being represented by Lee Rasmussen, so I assume that they've
So they can
been
take
giving
care
him
of
good
themselves.
advice. Right.
Lee can take care of himself.
That's right. Good.
All right, further discussion? All in favor?
Aye.
Opposed? All right. So Andy, do I read this?
Well, I have a suggested motion for whomever wants to make the motion.
Let's have a.
You can just read about the top.
To just read. this
Read,
part.
yeah, to the where the stars are.
I move that the Albemarle Conservation Easement Authority convene a closed meeting pursuant to section 2.2-3711A of the Code of Virginia. Under subsection 8, to consult with legal counsel regarding specific legal matters related to the interpretation of conservation easement language, addressing permitted land uses, which require the provision of legal advice by such counsel.
Can the chairman make that motion, or do you want to peg it on one of those guys?
The chair can make the motion,
Need a second.
I'll second.
and then there needs to be a roll call vote.
Okay. Director Buttrick,
Aye.
Director Merrick,
Aye.
Director Moses,
Aye.
Director Fennell.
Aye.
Director Linville.
Aye.
Director Moore. Director Taylor.
So we'd
Thank
ask
you.
all non-members to leave the room, please. You are welcome to stay here, but not participate.
And to clarify, Andy, I'm now going to mute us and turn
Yes.
you off.
Yes,
Keep
please.
it
Oh, it's, yeah, so if we could, I'm sorry, record, make sure that we're recording again.
Sorry, the recording had started, but I had not unmuted myself. So I'm very sorry. Would you mind reading that again?
I move that the Albemarle County Conservation Easement Authority certify by a recorded vote that, to the best of each member's knowledge, only public business matters lawfully exempted from the open meeting requirements of the Virginia Freedom of Information Act and identified in the motion authorizing the closed meetings were heard, discussed, or considered in the closed meeting.
So if we could take a roll call vote now.
Do we need a second?
Oh, I'm sorry.
Second.
Thank you. Director Buttrick,
Aye.
Director Merrick, Director Moses, Director Fennell,
Yes.
Director Linville,
Aye.
Director Moore,
Aye.
Director Taylor.
Aye.
Thank you.
And then did you have a statement to make?
I declare that I disqualified myself from participating in the discussion and consideration of this transaction at the ACEA public meeting of November 13, 2025. Request that this fact be recorded in the appropriate public record for a period of 5 years.
Thank you.
So you're gonna give us an overview of that.
Yes. Yeah, that's right. Thank you. So this item is for a homestay application that has come in on an easement property. We're joined by Russell Nance and Amy Stevens, who are the applicants for the homestay. The property is one of the preservation tracts on the Ragged Mountain Farm rural preservation developments. And the homestay is for, or the homestay application is for 2 bedrooms in the single family dwelling here in the southeastern corner of the property. Just to give you a bit of background for homestay applications, since this property is owned by an LLC, the applicants also have to apply for a special exception from the board. Good idea, thank you. Also have to apply for a special exception from the Board of Supervisors to designate the resident agent who will be resident on the property while the homestays are happening. And the applicants have designated Sydney Brown, who is one of the members of the LLC who owns the parcel, as that resident agent. The easement is held jointly by this body and by the Board of Supervisors. So what is happening tonight and the interpretation and determination tonight will also happen in the board's capacity as the holder, as well as the board reviewing the special exception. The deed permits one primary single family dwelling and commercial uses that are subordinate and customarily incidental to a principal use of the property. It's staff opinion that 2 bedrooms within the single family dwelling is subordinate and customarily incidental. And we have, to come to that conclusion, looked at what has been happening in the history of homestays in the rural area. The county has permitted homestays in one form or another since 1976. It's a common practice, and that lends us to believe that this is customarily incidental. The fact that it's only 2 bedrooms in the dwelling and one of the owners is living there leads us to believe that this is subordinate. And we have a lot of deeds with this language. We haven't encountered a homestay use on any of those easement properties. And so there's no precedent for staff to judge one way or another whether this body feels that homestays are subordinate and customarily incidental, which is why we're bringing it to you all to get your opinion and your advice. It's our recommendation, however, that the homestay use is consistent with the terms of the easement. We can take any questions, and you also have the applicants here who I believe would like to address you.
The single family dwelling there now has a total of 2 bedrooms?
No, the applicants can confirm exactly how many, 5 or 6, I believe.
Right now that it has 5 or 6 bedrooms?
No, it has, 3.
Yeah.
Did we hear from what they intend?
That's up to you.
You all like to give us any flavor of what the plan is and
Sure, I'd be happy to. Sam, sitting's good?
Sitting's fine.
Whatever works for you.
Okay. And by the way, so I read the agenda on the website, and the agenda has guidelines for speaking, and the guidelines say when to come, which is in the other matters. That's why I had read that. I was concerned that was in place. That was all. So in this house we have the main living space.
Could you identify yourself?
Oh, absolutely. I'm Russell Nance. Amy Stevens, my sister Amy Stevens. We are two of the owners of the LLC that owns the property. My niece through marriage, but not Amy's niece, currently lives in the property and is an owner of the LLC as well, with her fiance. And we also have 2 additional bedrooms upstairs that are unoccupied. And our view of this is that a homestay is subordinate and customarily incidental to a single family primary use. Even self-evident to me, but the extent not. You know, there is a robust ordinance that governs homestays. So it's not, there's a process. It is quite robust. And it seems to be an easement here. I know that I need to go much further. It's not it's not a difficult legal argument.
so I just want to make sure I'm clear on this. So the home has 3 total bedrooms right now. Is that right? You mentioned 2 rooms upstairs, or is that in the calculation of 3 or?
Yeah, it is. It is. So there was also an in-law suite, but we have taken that. So that's no longer.
Yeah.
So there are a total of 3 bedrooms in the house. And 2 are separate space. Otherwise unutilized. So it makes sense for us to utilize.
Right.
The residence is on separate facility.
The residence, that's a good question. So the entire piece of property is owned by Ragged Mountain Farm LLC. That LLC has multiple series, which have different owners. I'm an owner of both. And this Virginia, if you look at the Virginia series LLC statute, it's separate owned, managed. So that piece of property is now separately owned and managed from the rest of the Ragged Mountain Ragged branches.
I think you actually confused me as opposed to adding clarity. The parcel is owned by which LLC?
So Ragged Mountain Farm LLC is a series, which is a part of the Virginia LLC statute that allows for multiple series. They're effectively somewhat legally the same, but they're not. They're the same legal entity. But what it allows for is separate ownership or management of a particular group of assets and ring fencing for liability and other matters like that. So this particular property is now still owned by the LLC, but in a separate series entity.
When you say this particular property, you mean the dwelling,
I'm meaning the entire 92 acres.
the entire 92 acres.
Yes.
And what's the relationship between the dwelling and the distillery?
Oh, it's all integrated, as it has been for
Same LLC,
same LLC.
different series within the LLC.
No, same LLC for that entire piece of property, same series of that. The Ragged Branch production has moved to Augusta County, but in the same LLC, but in a separate. And the purpose for this is to allow Ragged Branch to do their thing and to allow this piece of property to operate, you know, in an affiliated capacity.
And I apologize if I drag this down the rabbit hole. It is irrelevant.
So the Ragged Branch use is no longer on this property.
Well, yes and no, because this property is still, it's still, you know, still at the store, still producing spirits.
Oh, it is. Oh,
Yes.
okay. I'm
Yeah.
sorry. I misunderstood your Augusta County reference.
I know, it's complicated, and that's because it's a complicated arrangement. But the Ragged Branch's production facility, which was not able to be done on that piece of property, it's created over in Augusta County, and that's still part of the same, still owned by the same umbrella LLC. But in a separate series, it's managed distinctly.
So the product is still processed on the 92 acres.
Yes.
Okay.
Bottled in Augusta?
No, there, so this is where it's getting complicated because and this is,
Maybe we don't need to
This
even
is-
have this.
I don't think we do. I don't think it's relevant, but I do want to be open and
No.
honestly give you the information. This
I
is-
honestly don't care. It's not relevant.
So with regard to the LLC, are they the same members and how many members are there?
So on the Ragged Branch side, there are 6 members. I'm one of them. And on the other side, there are 1, 2, 3, 4, 5, 6, also 6.
Yep. He's the only one.
On an element?
Sorry, I just, again, I'm, the securities industry, I should be able to do it. It was in my head a little faster, but I apologize. So the bourbon or whatever the whiskey is you're making is made in Augusta County and costs back the tasting room. Is that right? And then
We're making our own spirit on this particular piece of property.
Got it.
Ragged Branch is making their own spirit in Augusta County,
separate, different kind of spirits.
different kinds of spirits. Okay.
Fair enough.
We still have, and there were significant amount of spirits made on this piece of property that are Ragged Branch spirit, and we can still serve them and taste them.
Are you still inviting the public?
Yes.
So have you made application to Albemarle County to go through the various steps you need to go through for the homestay operations?
Yeah, we've made the application, it's been inspected. As far as I know, the only thing that is remaining is this and the Board of Supervisors meeting.
So do you have to go before them and do what you're doing here, or is that?
Probably a good question for James.
Yeah, I mean, it probably remains to be seen, and that answer probably depends on the outcome of this meeting.
Although the Albemarle County Board of Supervisors vote within their own interest, right? I mean, they might take a cue from us, but they're an independent body.
I'm,
Yeah.
So, in that vein, is this an administrative potentially approval on the zoning side, or is the Board of Zoning Appeals or the Board of Supervisors?
It would be administrative if the property was not owned by an LLC. Since it's owned by an LLC, the applicants have to go to the Board of Supervisors, and that becomes a legislative decision.
Okay, so just to be clear, that's a whole separate process, that there's another approval process.
Yes,
We're not
Yeah.
even sure whether we have an approval thing here or not, potentially, so.
right.
And it's an approval, I might add, an approval of a different issue, which is allowing a resident manager, whether to allow a resident manager to have that homestay.
Just to clarify, with you, there is nothing in the deed of easement that requires us to approve this use. Is there? I mean,
That's
what
right.
I mean, it's not a, if this is consistent, if this activity is consistent with the terms of the conservation easement, it's not requisite for us to approve it in order for it to be consistent.
That's right.
So could do nothing if we believed it was consistent and the applicant could move forward and
Yes,
do their activity. They
right,
don't need our approval
right.
to do that.
The staff recommendation is only to take action because I don't think we would recommend no action in this case. Staff is, or at least it wouldn't be a staff recommendation to do nothing. Staff brings questions of these sorts of interpretations to you all, but doing nothing is an appropriate response.
It would seem that there is a strong rationale for us to take no action. For at least two reasons, and maybe three. One of them is that the intention of the Rural Preservation District was to keep it consistent with the surroundings. This appears to be a commercial use with regard to the distillery, and now another one that is rooms for rent. Not clear that the Board of Supervisors had that in mind when they allowed the rural preservation process. Secondly, it isn't clear that we have a need to take a position since we're independent of the Board of Supervisors on the county structure. We're an independent authority. And therefore, I would suggest that be silent.
I think that I would agree that that's the best path forward. The Board of Supervisors, but it sounds like that's gonna happen sooner than later.
Yeah, I think some of the distinctions we talked about earlier are distinctions that are more appropriate to be made by and will be made by the county. So to my mind, we should lay this on the table without prejudice.
I think the without prejudice clause is helpful.
So I don't believe we need to take that vote.
And I think mostly helpful for staff.
Yeah, I mean, there's
to-
guidance for staff.
Yeah.
So James, what you had explained is because these are 2 bedrooms, it meets the homestay zoning issue. What makes it have to go before the board is that it is an LLC and one of the members will be residing in it, and they need to hear that and either approve it or not approve it.
Right,
And that's for special permit, or what do they call that? For
a special exception.
special exception. Okay. And we don't grant special exceptions.
No.
and They do.
It's a special exception from the rule that the owner must live on the property because an LLC cannot live on the property.
Okay.
So they have to
Right.
have an exception from the rule.
So if there are no further discussions, I think that's the path forward for this body.
That gets you what you need, or at least not get you what you don't want.
Are you talking about?
Yeah.
Yeah. Yeah, I think so.
I mean, I understand James did a great job bringing it to this body, and so we're aware of it. We know what you're doing, and we're no surprises, and then it'll go before the board of supervisors. And you'll keep this posted.
Right, we, as staff, we had no guidance on this issue.
Yeah, thank you for bringing it.
And
Yeah,
this,
and
this
thanks for
is
coming.
sufficient.
And helping clarify things.
No.
Part of it.
The other part.
I gotta go read up on
So
series
we're
LLC.
gonna come taste the spirit.
Because I do have more questions.
It wasn't perfect, so.
You just want to know
Okay.
if they're two different kinds of bourbon. That's what you want.
Yeah, it's about the two different.
I know where you line of questions go.
Now it again.
Clearly irrelevant to the discussion.
Okay, thank you. Thank you.
Yeah.
Yeah.
We got.
You may.
Thank you.
I'm not good on the protocol. Thank you for your time. Sure.
New biz?
We do have one piece.
Hmm.
Clifton Lake.
Sorry. We have new business. New business for an ongoing violation proceeding that we want to bring to your attention and talk about our proposed next steps. The property is, sorry for the washed out map, the Clifton Lake donation, which was donated in 2014. This over here is the Pantops I-64 interchange. The Clifton Inn is directly to the west. The deed includes riparian buffers, 200-foot riparian buffers, within which no dwellings, buildings, or structures may be built other than fences. And it currently looks like this with the buffers in blue. It's split into two parcels. It's one easement, covers two parcels, two separate owners, Mr. and Mrs. Black in the north, Ricky Bobby Properties LLC in the south. And both owners have built structures in the buffers. This is now twisted. This view is from the west, so north is to the left here. Let me get laser. This boundary line isn't quite accurate. It should be in the middle of the inlet. So Mr. and Mrs. Black have built a concrete pad, steps, a dock, and a small storage shed for the boats. Ricky Bobby Properties LLC has built, at the time of this photo, two kind of observation platforms in the trees and a dock on the lake. We have better pictures of this dock, which I'll show you for their own sake, and also to point out that the owners have listed this southern parcel. It's a vacant parcel, and so the dock and the observation platforms are featuring quite heavily in the listing, as you might expect.
And it's for like
This is Ricky Bobby.
blacks. So, yeah, it's listed for like over $7 million.
7 million.
Yeah.
That's right. It was listed 5 or 6 weeks ago.
Yeah, yeah.
And so these points show the approximate locations of the docks and the platforms. And staff tried to make contact with both owners in the summer, successfully made contact with Mr. and Mrs. Black, and told them that this is in violation and must be removed. The owner of Ricky Bobby Properties was much harder to get hold of, Mr. Matthew Miller. Just last week or the week before, we followed up with Mr. and Mrs. Black and happened to also make contact with Mr. Miller and met them both on the property. The Blacks have not yet removed the structure, and Mr. Miller pleaded ignorance of the violation despite multiple emails and letters to that effect.
Did Black indicate that his intention was to remove?
Black did not.
Did
Black
he tell you where to
indicated
go?
a willingness.
What was the prospect of further action or inaction?
I would say the prospect of further inaction, as far as the structures are concerned, is high. They were very willing to negotiate with this body and asked about negotiating, you know, how can we make this work? How can we make this happen? We explained that these are in violation and they must go. They asked about amending the deeds,
Make it more restrictive.
at which point we explained that there is an amendment process.
Yeah, 400-foot setback.
But that it would be highly unlikely for them to be able to propose an amendment that would permit the structures that are currently there.
Did you flip back to the operative language in the deed?
Yeah, I was gonna ask
Yes.
the same thing.
I mean, it's absolutely nothing except fencing, and we're clear on that, right?
No new dwelling, building, or other structure other than fences shall be located within the buffer area. And the buffer area is defined as 200 foot wide, measured from the top of the stream or pond bank. So I think there's an argument to be made that the docks themselves that are in the water are not within the buffer, but both docks have substantial structures actually on the bank.
What's the history of these easements? Two different easements, those donated,
One easement, two parcels.
subdivided.
It was two parcels when it was donated, and
But under one easement.
under one easement, a separate ownership was permitted.
And how recently did the current owners purchase them?
The Blacks purchased them shortly after the easement was donated, 2016, I think. Ricky Bobby Properties, I think, purchased in 2023. They inherited a big zoning violation. The previous owner had done forestry on the property, and by zoning rules, forestry was not permitted. There were structures that weren't allowed to be there.
It's previously Dr. Hurt's property.
Yes, Dr. Hurt was the donor.
Right.
How long have these structures been here?
The the southern parcel structures were constructed sometime between summer of 2024 and February of 2025.
This is not,
Well,
highly untimely.
Do you have
The-
pictures of the other structures?
The northern, no, we do not. The northern structure is more untimely. That was built, if I'm remembering rightly, 2021. It was sometime during lockdown. It was kind of
and these came to light only inadvertently.
they came to light because Montana, our field monitor, contacted Mr. Black and asked to visit the property for a monitoring visit, and he said no. And so we looked at this.
The Clifton Inn owns the other side. Did they have any structures on the bottom?
They have a dock. It's very similar to the southern dock.
But that's not an easement, that's not.
No.
Somewhat irrelevant to what the easement says, but more just a curiosity. Did they pull a building permit for Blacks?
None of these structures have building permits, and all of them need building permits.
And had they gone to the county to pull a building permit, it would have been flagged through the easement system. The county maintains.
Hopefully, at that time, I'm not sure the system was working, but
Maybe it was.
right, it's been faulty. It is now working. If anyone now applies for a building permit, it is flagged.
You know that you would need a building permit for a dock.
It's the landowner's responsibility to know.
I mean, is it easily found in the county code, or
Ignorance of the law. is
does
no
the
excuse.
contractor know that he's supposed to go get?
They should.
Contractors.
Almost everything needs a building permit in the
Talking
county.
about more than just docks here. There's a structure up there.
There's a storage shed, yes.
And then there's that thing up on top of the hill.
And so
why are
I-
we having this conversation in closed session?
Well,
What,
good question.
What action are you recommending?
Thank you. Our proposal is to write letters to both owners saying they must, this is a violation. The structures need to come down within X number of days. Otherwise, the body will pursue enforcement. Sorry, it sounded like there was more. That's
That letter
that's
would
it.
be written with advice of counsel.
yes. definitely.
Sharon, I'm sorry, did you say that one of these things is listed right now for sale?
The one, yeah, on the right, yeah, and it's got multiple division, right?
Is there,
Or it says in there, it's got several building sites or something.
It has several building sites. It advertises several building sites. They can build one, maybe two dwellings.
Let's not divide.
Is it
Not-
advertised as though it can be subdivided?
No. No,
Is
There-
it advertised getting it?
we've contacted the real estate agent to let them know. But there are other issues with the advertisement offers building sites with prime views of the lake, for example, and we've pointed out that to get those prime views, they would have to cut down the trees in the buffer. Which are
That's
not
all,
allowed.
notifications already.
Yes.
is there a way, given that that property is on the market and actively being sold, to get into the land records an opinion of this body that the property is in violation of the easement?
So in order to do that, there need to be a lis pendens. I mean, what you're suggesting is a lis pendens, and what that is a notice that there's active litigation on something. So the title record for this property already reflects a conservation easement. There is a conservation easement that anybody performing a title exam of this property is going to find, and they're going to see the restrictions and the fact that these contradict the restrictions. So
We're giving them far more credit.
well, so a bona fide purchaser of a property for this amount is most likely gonna require title insurance. It's gonna have a title exam done. That title exam is gonna spot the conservation easement. Now, whether they go further than that, remains to be seen. But to do what you suggest, have a separate instrument that sort of highlights this issue, that again, that would be a lis pendens, and that would be.
Mechanics, if you will.
Well, it would be putting people on notice that this
Yeah.
property was in active litigation. Hopefully, that's something that can be avoided.
Sure.
So
So that's the only thing that would give us leverage to have something like that, would be active litigation.
I don't. think
in
so.
order to create another recordable instrument in addition to the one that's already
Yeah.
on the record.
If the owners, and maybe the real estate agent, were officially notified that these have to go, and that these advertised parcels, in fact, were not buildable, and they didn't find.
And they don't split it.
I think that's flawed. I mean, nobody in there, that great, given the sale price.
And you'd sort of want there to be a flaw in the title
That's what I'm looking
for a mess like this, And that's what the lis pendens is.
But it also
would do,
seems like
right?
that, to Peter's point, a letter that went to the landowner that could also go to the listing agent might have some additional effect.
Certified letter.
Now, is that tortious interference of the contract?
Well, I mean, and this is a discussion that we've had at the staff level of how to communicate that, and that was precisely my suggestion is sending notice to the property owner with a copy to the listing agent. And saying basically, consider yourselves on notice that it just as a reminder that this is what the terms of the easement are. And if the primary goes to the landowner with a property to the listing agent, then the listing agent is also on notice of the problem.
Make it so. What's the purpose of this conservation easement and the purposes clause? If so, there was is that, and also exhibit A, you have an image of exhibit A?
I do have an image of Exhibit A. Exhibit A was created with inaccurate parcel lines. For our purposes, the structures are still within these buffers as shown. They're on the bank of the lake before this slight dogleg. So I don't think it matters that these parcel lines were inaccurate. I've pulled here the boundary line adjustment and that was used for the sale. This is as the properties are now. This is the more accurate boundary line. It follows the lake all the way down here and beyond the dam and comes across to join here. And this plat marks the 200-foot buffer as restricted in the conservation easement. which is not a requirement. 2015
Prior
It-
to or after the easement?
after the easement.
So that plat is some ways irrelevant to the terms of our easement. I mean, I agree with you.
Right, right.
So it was recorded after. The hatched area is the wooded buffer. Show me where the stream buffer that's referenced is shown on exhibit A.
I cannot say.
Language again?
Yeah.
In the easement?
One second. Oh,
Shall be located within the buffer area as shown on the map attached here to it. Okay,
So
so
let
that's
it refer to.
lesson for you in the future. You didn't write this, neither did I, but that should say wooded buffer area or stream buffer. I would use
Something to match the map, is that?
Something to
yeah.
match the map.
So back to your diagram, that's the lake on the one on the left. That's the lake in the middle. The other one that you had. And
But-
their property line goes to the center of the lake.
No, this is the lake here. This is a small inlet. I can show you.
So does their property line stop at the edge and it doesn't include any of the water?
No, the property line goes through. So if you see this line going through the lake here, I'll show you
Right, so their
is this
property
line.
Goes kind of into the middle of the lake.
Yes.
So can they say, we don't have access to our property without the use of this dock and these steps?
That would be a question for council. I don't know.
It's not a landlocked property.
Yeah, it's not a landlocked property.
It has road access.
And they could always simply hop out upon the bank.
Right.
But the easement prevents them from accessing the water.
Not really. You just-
They could walk
Yeah.
down to
Sherry says they can.
They could walk
get
down
in.
to the bank with their canoe and hop in.
And even if it did restrict them from accessing the water, that's not a taking. So, I mean, I hear what you're saying, that makes the property less desirable, but my answer is,
That's the
So-
point of the easement.
right,
The easement was intended to make the property less desirable.
right.
Two things here is we're doing a technical purpose or favor by flagging this through the appropriate channels.
I'll
And,
say,
and secondly, there's some history here in this county of properties being offered for sale that are under a conservation easement. Where an inference is made by someone along the way that those restrictions can be disregarded. And in fact, there's a case under it that went to the Supreme Court. So it would suggest to me we should send the letters as you have proposed with copies to the agent.
Start with that.
With copies to the agent. I'd be happy to make a motion.
Well, with regard to the Black's property, what you want, what's there, you want it all removed.
Anything in the buffer.
Right.
All,
Anything in the buffer.
anything, well, I guess a better way to say it is anything that's not permitted for the terms of the easement, which would be structures.
Yeah.
Other than fencing.
Is this lake open to the public?
Don't believe so.
There's no scenic value from the water, as it were.
Well,
Only,
that's why I was
only for
asking
the,
about purposes. I
um,
was wondering what purpose. I'm just.
Yeah, I was just reading through it. A lot of it's the comprehensive plan.
Yeah.
And it
And,
mentions scenic, but it doesn't,
But does it mention ecological function and water quality protection?
I think in passing, it mentions water resources. I mean, you're welcome to borrow James's if he'll let you.
But again, my way of thinking it, structure, not the dots, they're all bad, right? But when it comes to severity, they're two significant structures.
Yeah, what are those structures and why are they?
The boathouse.
One looks like a boathouse, the other, what did you say, it's like a viewing pad or something?
Yeah, it's just a.
yes,
Like a pavilion.
this is so this is where we had the meeting. It's a small storage shed under a kind of porch roof with some deck chairs and a fire pit on a concrete pad with concrete stairs leading
So it
down to
doesn't
the
have
dock.
Walls, except for the little.
The storage shed has walls, which seemed big enough for a few kayaks or canoes.
Can they keep the concrete steps in the pad?
It's
Can you
my
reach
instinct.
steps?
It's
I mean, or you
yes.
just have to take a nosedive. to
You
get to the
can reach
concrete?
it. It's my instinct that the concrete pad and the concrete steps would count as structures, but I
Well,
haven't.
it's not
looked at
vertical,
them.
it's,
Right.
you can have a road, you can have,
You can't have a
Well,
paved
can you
road.
have a road in a buffer? Maybe not.
You can't have a paved road. And that would be paving. So it feels like they wouldn't be.
Yeah, I mean,
But
they're
I-
impervious surface, which is a
Right.
bad water quality.
Right.
I mean, you can even argue that a flat open deck is non-structured.
But there's also a no clearing.
Right.
Provision.
Including but not limited to the water resources and environmentally sensitive lands. Boom.
There you go.
So does the county have any appetite or see any opportunity to amend the easement? I mean, are there things you would want that you could get?
trade off.
Like what?
I would be surprised. I haven't looked at the natural resources on this property, but
You really even want to open that?
Yeah, I don't
Right,
think
that's-
I don't think that's this road we want to go down.
the only thing I can think would be if this is some sort of important habitat that we could protect the forested area, and it's not important
I mean, if
habitat.
there were two houses and you could have one instead, that sort of thing, you know?
Mm.
If it were 6,000 square feet of
Mhm.
impervious and you could have,
Well, Rick and
2,000.
Bobby doesn't have a house.
No.
I'll give them a dock, with no house.
Well, I think you should be consistent, not one over the other.
He built a structure. You know, it is how- Andy, what's the over under? This like thing becomes like push comes to shove. Like this goes all the way to court.
Over under of what?
Who wins if this goes to court?
Oh, I mean, I think that, given these facts, that they're pretty clearly in violation of the easement.
So you feel good about it?
Well, nothing's ever, there's no,
They go-
there are no
Good,
guarantees,
good,
but
good.
this seems pretty clear cut. No pun intended. I
It
mean,
doesn't feel ambiguous.
No.
Doesn't to me either. Oh, the only thing I look at is like, I wish the definition of the buffer was a little bit clearer, but I
Yes.
just don't think it's.
Or structure.
I
We
don't-
would have thought a concrete
structure's not
pad was a
defined, but-
structure.
But the fact that
You can
structure
debate
says
that.
other than fence gives us a pretty broad definition of what structure is.
Well,
What's the county's recourse of building with no
That's
permit?
usually the
well,
structure.
that's another violation. So, I mean, you sort of compounding the violations here.
But what's the county's typical recourse on that, you know?
We've got a pretty aggressive building official.
But it's not remove building, it's pay, pay your fine.
It-
And-
it's get a
That's what
permit.
I think they-
It's get a permit and you can have the structures, which is why
But they may not be issued a permit if it's in violation of a county-held
never
conservation
seen.
easement, or if it's in violation of floodplain. So
we haven't heard any indication from zoning or building officials that these structures need to go.
are they aware?
They're aware.
And are they aware that they're a violation, that this body believes that this is a violation of the constitution
Yes.
held by a county body?
Yes.
And these are second owners. They knew the limitations when they bought the property.
Maybe,
It
but
states,
wouldn't put yourself in their head.
it states in the deed that they signed that this is, they're requiring it pursuant to a recorded deed of easement, and it gives the reference to the easement that was recorded.
And as you may recall, that's a requirement. The conservation easement deed requires that every successive transfer of the property cite back to the deed of easement.
Which is smart.
And so it sounds like they did that.
They did in this
And,
one.
and we, in our meeting with both owners, we told them that when they were crying foul, we told them that you knew what you were signing up for when you bought it, and they didn't challenge that.
So other than, what do you need from us tonight? to put you in the strongest position possible moving forward.
I think I have what I need. That you agree with our course of action. You now know what's going on. You know that there may be amendment applications in future, or whether there are or not, maybe legal proceedings. There's no motion required.
Well, I just want to say that I kind of abstain. I know the blacks, and I would like to see some other thing than legal, but it'll take
Yes.
its
We
course.
all would.
But I think there is some definition of it's our property, it's our pond. I understand the easement. What's a structure? What's a structure? I gotta bust up the concrete pad and the steps, but I could have a fence railing down there if I wanted to hold on to. So,
All right, the strongly worded letter. The owners and the agent.
Is there like a, like this, okay, so what would be the timeline?
Right.
Right, so you write your strongly worded letter, which sounds so freaking weak. And then what? Like like how long do we give them? What's the next step? Like what? Do you have thoughts? Have you guys thought that far down the road yet?
I have thoughts, and I would ask council for their advice. We don't have a standard procedure. Even before this was going on, I was working on trying to create a standard procedure such that we always know how long to give from each one. And but no, that's something we would try to give them time enough that they could get someone in and remove the structure, but not time such that they can kind of drag their heels and sell it.
We forget about it.
Right, and we're not going to forget about
Well,
it.
you could say reply to this correspondence should be made in 30 days and removal within 90.
And this is a certified letter that they're gonna get?
Yes,
I'd say so.
so
Yes,
to my way of thinking, go hand in hand with the building inspector, because they've got authority to play, right?
Well, and if we talked about loosely following the procedure and protocol, if it were a zoning violation also, until it bumps up. Where, they'll try to, zoning would appeal and these guys would try to amend. That's our bottom line. At this point.
I mean, there's no thought that zoning is gonna okay this in some way. I mean, it would
Well,
be nice if zoning would come in as,
right. And that's why we have
Actually, our cudgel is bigger than theirs, to be quite honest.
we don't have standard procedure because every time this has happened in the past, it's also been a zoning violation. And zoning has come in and zoning has also required whatever it is to stop or be removed. And so we just kind of follow on the coattails of zoning. In this case, zoning's end goal is they get their permits. And I'm not sure they can get permits for these, but I haven't heard anyone say that they can't. So Scott and I have been kind of
for the easement,
for the easement.
they would get the permit except for the easement.
Yeah.
The easement does not interrupt the zoning process.
Purely from the easement perspective.
well, it's custom built a home, so they got all those permits,
Right.
and it's a large home.
Yeah.
Yeah, so all of that in the garage and this and that, all of that was permitted.
Mhm.
How do we know that that wasn't built the same time? When they
Because
built the
we
concrete?
have those aerials and historical aerials to see
Okay.
when the house was built and when the structure.
So James, this may be that letter that gives them X amount of days and goes to the land, certified letter that goes to the landowner and to the realtor. Should also probably be CC'd to the building inspector. Yeah.
We can do that.
I would think internal discussions between your department and their department
There have been
should
internal
come
discussions.
to a conclusion that they mustn't give a permit to something where it's a violation of the easement.
we've been told we cannot request that of zoning and building stuff because it is not the county's job to enforce terms of what is practically a private agreement.
Apropos of the
Oh.
sent earlier today.
I know,
That is,
But-
that is not a good
but
thing.
would you have zoning reject a permit based on a VOF easement?
Yes. In fact, I think we're pursuing trying to
Right.
get that done in some counties. Or maybe statewide.
I agree that it would be good, but that doesn't happen here at the moment.
I say we send a letter and I can't imagine in a million years anybody with any certification would proceed with that notice. You're setting yourself up for a big fall.
And the real estate agent is also doing so.
I'd also like to think about, on the wording of that letter, removal and restoration
Mhm.
for the violation.
Mhm.
You know, not just removal, but it's removal and restoration of the condition. And I want to look at again, our rights under the easement as it relates to remedies, probably back here, if we can get back in for violations. But again, work with council to use appropriate language under our enforcement clause. Parties shall have the following rights: monitoring restoration upon breach of any term of this easement by the grantor. The grantee may require by written demand of the grantor. We need to be doing everything in here consistent with what we are allowed to do under the easement. To the grantor, that the property be restored promptly to its condition at the time of the easement was granted. You have a baseline documentation report for this?
Mhm.
So citing your baseline documentation report as the document that gives you the condition of the property at the time the easement was granted, and we want restoration to the condition of as shown in the DDR. And I think that's what we want to make sure that we represent, that we know our rights, and that the rights that are granted to us in the easement.
Just out of curiosity, all these photos, the county has aerial photos sort of on an ongoing basis, so
Mhm.
is that Google Earth or?
No, it's a company called Eagle View. I don't know how it works, but
There's
it's
state data and the county has its own that it applies
high resolution.
It's better than Google Earth.
better. Yeah.
Oh, it's much better.
Good data.
Yeah, it's pictometry, so it's a much closer scale.
All right. Got a plan?
They see more and more of this kind of thing.
Again, that's also cited under legal proceedings.
But I think that letter needs to cite that very section.
Yeah, I mean, that's what I'm saying. It's like enforce in the letter, I would reiterate our enforcement rights for the deed and our restoration rights.
The letter will come from staff or from this body?
That's up to you all.
What's
What do
legal
you
counsel
recommend?
recommend?
I mean, it could even come from our office if that were the direction of,
That would be preferable.
Oh, yeah. Blue stationery
Letter
is
from a
always good.
lawyer.
we don't have blue station. But we do have county attorney station. And oftentimes, rightly or wrongly, that's taken more seriously,
Yeah.
so.
Yeah, that gets attention.
All right. You don't need a motion for that, do we?
No.
No.
Okay. Any other business anywhere?
Old business and adjournment.
Motion to adjourn?
Second? All right, in favor? All right, thank you, ladies and gentlemen.
You all have a, after.
Yes.
All right.
Andy, it's good to see you.
Good seeing
Yeah,
you.
because of interactions.
It's been a while, but,
No.
Thank you.
So I.
I drew you a,
This amendment.
The current-
Yeah, that's.